Thanks again as well to Datamine for the invitation to present today. I would like to start today by acknowledging the traditional custodians of the land, the Whadjuk people of the Noongar Nation, and pay my respects to their elders past, present and emerging. As David's already touched on, DLA Piper is a global commercial law firm, but one of our key focuses here in Perth is the mining, energy and natural resources sector. So my role does involve the dispute side of that in the sense that we do a lot of work with mining and exploration companies and proceedings before the mining warden and in the Warden's Court. So today I want to briefly cover a few things. I want to cover the general procedural overview of administrative proceedings before the mining warden under the Mining Act. And then secondly, I want to talk about the management of those proceedings and the key practical developments we're currently seeing in that jurisdiction. And then I'll delve into sort of the two most common types of proceedings that we deal with, which is objections to tenement applications and objections to exemption applications and forfeiture applications under the Mining Act. Understanding how these processes work are really important to navigating not only the proceedings themselves, but managing your internal stakeholders and expectations and your tenure now and in the future. And as we go, I'll sort of briefly talk about recent legal and practical developments and hopefully provide some useful tips that you can take away with you today, and hopefully there's at least one. And of course, time pending, there may be some opportunity to ask questions at the end. Otherwise, I'm happy to speak to you specifically if you want to get in touch. So as I mentioned, there's two functions of the mining warden here in Western Australia. One is an administrative function and one is a judicial function. Depending on the function being exercised, the warden has different powers and processes under each function. So when we talk about the Warden's Court, we're talking about the judicial function. And when we're talking about proceedings before the mining warden, we're talking about administrative proceedings or the administrative function. And those terms are often used interchangeably, but there is a distinction under the Mining Act, and that's part of the reason why I changed my presentation title today. So we'll be focusing on that administrative function of the mining warden because we do currently see a greater number of proceedings currently before the warden, and that landscape is constantly changing. We did actually run some figures, they're a little bit small on the screen in the bottom corner, using LandTracker actually, and based on that data we can see that currently there's about 2,948 tenement applications with objections, and often you'll get more than one objection, so that's a lot. There's 69 objections to exemption applications, and there's 184 forfeiture applications currently active, and as I said before, these numbers are constantly changing. On the screen, we've got a bit of a flowchart which shows a very, very high level of the overview of the procedural steps from start to finish of administrative proceedings. There's two very important caveats with this flowchart. One is it's flexible. Proceedings may go in different directions at different times depending on the party's conduct, anything that arises in the meantime, and in terms of interim disputes and any directions by the mining warden. The second one is this is a very basic minimum steps to get to a final decision. And as you can see, there are a lot, but we often see a majority of the proceedings resolve around the evidence stage. And rarely do these proceedings go all the way through to a hearing before the mining warden. So very, very briefly, the first step on there is obviously the commencement of the proceedings before the warden, which is either following the lodgement of an objection, which is sort of shaded in the green colour, or a response to a forfeiture application, which is shaded in blue. The matter will then go to a first mention or an initial hearing before the mining warden, where the warden will either make directions for the next steps or he might push it to another date or adjourn it. And that might be because the parties are trying to negotiate a resolution or an access agreement. The next, and probably the first substantive procedural step, is the preparation and exchange of particulars, which basically are a document that sets out each party's case and really crystallise the issues and facts that are in dispute. This step is really important because it not only informs the parties and the warden of the proceedings and the basis of the proceedings, but it also can assist in assessing the merits and maybe even procuring a compromise. And I'll talk more about that a bit later on. Once particulars are exchanged, we'll then go to evidence, which is usually in the form of a written signed statement or affidavit. And that process is very time consuming. It can be costly to prepare that, especially if you've got lawyers involved. And so that's why we do often see matters resolved before it gets into this stage. Parties, they may then exchange written submissions, which obviously set out the legal and factual position of the parties for the hearing, and they might happen after the evidence stage or they might happen a bit later on. It is flexible. So following the completion of those sort of three main steps, if you like, the warden then refers the matter to a trial allocation date, which is usually the first Monday of every month. The proceedings will then be set down for hearing, and there's a bunch of steps that the warden will ask the parties to do in the lead up to a hearing, which is on the screen. Once it's been heard before the mining warden, then he'll make a recommendation, or she, and will publish written reasons after the hearing. And then that recommendation may be forwarded to the minister, who will make a final decision, or if one of the parties are disgruntled with the recommendation, then it might go to the Supreme Court on judicial review, if it's appropriate to do so. Of course, where the warden has the power to decide or grant a tenement, then he will make that decision and it won't go through to the minister. So I now just want to talk a little bit more about managing these proceedings and hopefully provide you with some more practical advice or tips in doing so. Not all proceedings are the same, so you really need to think about what side are you on. Are you the applicant or are you the objector in the terms of a tenement application? And if you're the applicant, you generally have the conduct of pushing the proceedings and are responsible for driving it. Whereas if you're the objector, you may take a slightly different approach. You then need to think about what are the issues and what is the materiality of those issues and what's the urgency. These questions will all inform you how to conduct the matter and your legal and commercial strategy, including to what extent do you focus on access negotiations or the proceedings, or ideally you would run those processes together. Those questions also affect the nature and timing of procedural steps, or what we call programming of proceedings, and your approach to mentions. Programming orders are something where you basically agree what you're going to do next in the proceeding, or you talk about it and the warden will make those orders. Mentions occur every Friday, so everyone goes down to the Warden's Court on a Friday at 10 o'clock and there's a whole list and we all sit there and wait patiently. But ideally, when you have a mention coming up, more recently, there's been a real push for conferral. So you do need to start thinking about what are you going to be doing at least a week out from a mention. From our recent experience, we've seen wardens allowing mentions to be adjourned up to 3 times for a period of up to 3 months each to allow matter to try and be resolved. But if it's unresolved, the warden will likely direct parties to program the matter towards a hearing. So what we're seeing more of is parties being pushed in that direction, where matters have been around or on foot for a while, and there has been more than 3 or 4 adjournments. We're also seeing more of a crackdown on parties not complying with warden's orders or directions and blatantly disregarding them, and the warden actually calling those parties to come down and explain to him why. We're also seeing, as I said before, more of an encouragement of conferral between the parties in advance of mentions. So often you'll see, well, if you monitor these sorts of draft cause lists that get published by the Warden's Court, there'll be a very, very long list, and then closer to the time, the list will be much shorter. And that's often because parties have talked and liaised and agreed some form of directions or orders. The other point I briefly want to touch on is costs. So parties should be aware of the risk of costs when navigating proceedings before the warden. Usually in this jurisdiction, each party bears their own costs, which means you don't pay the other side's costs. That's the most common approach. But what we have seen more recently is where proceedings have been frivolously or vexatiously commenced or maintained, or there's been undue delay. We've seen more of a willingness, shall we say, by the mining wardens to award costs to parties where expenses have been incurred in the proceedings, but perhaps ultimately, for example, the application's been determined invalid or even been withdrawn quite late in the piece. So it's something to be aware of. Forfeiture applications are a little bit different again. There are some basic procedural materials available on the Warden Court website to assist parties involved in proceedings. These include some practice directions which provide practical guidance on particular matters such as mentions or trial allocation hearings. We've got circulars to practitioners, which are more of a recent publication, which talk about recent developments that parties or practitioners should be aware of. And they've also published some template forms for orders made by the warden to assist in the efficient administration and processing of matters. And as I mentioned before, they publish draft lists and they maintain a decisions database, which is all publicly available through the department's website. And ideally, if you are involved in a proceeding, if you've got legal representatives, want to be tracking and be aware of these things as the proceedings are progressing. So some practical tips with respect to managing proceedings. Firstly, engage external lawyers early on, and ideally you want to get representatives that have the relevant expertise and experience in these type of proceedings. The earlier they can get involved, the much easier it becomes to manage in the long term and hopefully put a broader strategy in place to avoid going all the way through to a hearing if you can. Monitoring TenGraph and mineral titles online and ensuring if you do have external representatives that they also know how to use those platforms. Be prepared and organised. So diarising court deadlines and mentions, and if you have multiple, for example, objections to a tenement application, you might even want to keep a schedule of those proceedings with details and upcoming deadlines, because often it can get very confusing very quickly. And obviously keeping up to date with things on the Warden Court website helps as well in terms of notices and new legal developments. So as I said before, having an understanding of how proceedings work can not only assist parties in navigating the proceedings themselves, but they can also help companies in managing your access arrangements and agreements, your board or management expectations, your financial budgeting, and also your exploration strategies. I'm just conscious of time, so okay, great, thanks. So the first type of proceeding I just wanted to talk a little bit more about was objections to tenement applications. If an objection to a tenement application is lodged within 35 days of the application, the matter goes before the mining warden for consideration. And as I said before, sometimes one tenement application will have multiple objectors. Each objection and each tenement application will vary depending on the underlying interest and the type of tenement applied for. For example, there'll be different compliance requirements for an exploration licence compared to a mining lease or a miscellaneous licence. An objector, for example, may be a freehold owner, they might be an existing tenement holder or a pastoral lease holder, and that ultimately determines their underlying rights and what protection is offered by the Mining Act. Similarly, grounds of objection will often involve issues of compliance with the Mining Act and regulations, interference with rights or injurious affection, and public interest. Compliance issues have been a greater issue of contention post-Forest and Forest. I'm not going to delve into it today because I have limited time, but For example, what we've seen recently are the requirements of a compliant Section 58(1)(b) statement, which accompanies an application for an exploration licence. That's obviously been the subject of recent attention before the Warden post-Truefella, and it's now obviously before the Supreme Court. So much so that the Wardens have come out and published a notice saying that they're going to delay many of the exploration licence applications until September, while the Supreme Court hears and determines the point. So keeping up to date with those sorts of developments is really important, because as matters currently stand, particularly on that issue, there's still no real certainty. The other thing I wanted to touch on was, whilst there's also this, I would say, orthodox approach to lodge an objection every time there's a tenement application, one of the things we always say is what is important to pause. It's important to pause and think about to what extent is it necessary or appropriate to object, or what are my rights? Are my rights protected under the Mining Act? And to a large extent, the rights of objectors are often protected by the Mining Act alone. For example, rights of freehold owners are protected by sections 29 and 123. All the rights of existing tenement holders are protected by section 117, although there's some debate about 117, and that again is also a matter for another day. But in most situations, we see parties wanting to negotiate an access agreement to create some certainty on specific issues, and this is often because there might otherwise be uncertainty. So, for example, if you're an objector, you may negotiate to preserve the right to convert your underlying exploration licence to a mining lease. Or, if you're the applicant, you may dilute the right of priority through relocation clauses in your agreement. But one of the things that we see less of is these negotiations running concurrently with the proceedings, and sometimes there are benefits to running them in parallel, particularly where it can maximise the parties' positions and you can actually gain leverage in your negotiations because you're crystallising the issues up front in the proceedings through the various procedural steps. It also can then encourage meaningful engagement and also avoid dragging things on or unnecessary delay. Part of this, we've also seen a shift away from the use of minutes of programming directions since the Supreme Court's decision in Blue Ribbon Mines and Roy Hill. There has definitely been a greater push by the Department for parties to resolve access issues by agreement. There's been a little bit more intervention by the department where we've seen non-standard conditions proposed. The other thing we've seen is that Wardens implementing an open consultation process with the department for the imposition of conditions and grant, which was recently considered in a decision of Pilbara Energy and Hammersley Iron. So again, some practical tips on what we can do or what you can do if you're served with a tenement application. Pause and think about, do you really need to object? Ask yourself, is it necessary? What are you trying to achieve? Is it going to matter in practice? Do you just let it go through or do you not? Again, engage good external lawyers with litigation or Warden's Court experience to assist with the proceedings and access agreement negotiations. And that's really to try and maximise strategy. Sometimes you'll see different lawyers working on different aspects, which might be the proceedings versus the access agreement, and it's really difficult to manage your broader strategy when that happens. And so that leads me to my final point, which is, again, try and run the access agreement negotiations and proceedings concurrently, because you can crystallise the issues really early on, and you can essentially gain leverage and procure a compromise much quicker in our view. Finally, objections to exemption applications and forfeiture applications. Obviously, there's a lesser number of these currently, but there's definitely a lot happening in the legal space. So as most of you would probably know, mining companies have expenditure reporting obligations, obviously under the Mining Act, and each year, or for each reporting year, a holder is required to lodge a Form 5 operations report, which sets out their expenditure. Companies obviously should accurately report their expenditure for each expenditure year, goes without saying. But this can be tricky where companies allocate project-wide expenditure among tenements. A tenement holder ideally should make every effort to precisely identify the mining tenement upon which the expenditure was incurred, and to not simply arbitrarily allocate expenditure among tenements, unless there's some activity which doesn't allow expenditure to be precisely allocated. This was recently considered by the wardens in the New Cam Minerals decision. And I think in essence what we're trying to say is if you document what and why you are allocating expenditure, then this will help support any argument to the contrary. The other thing that we've seen in that reporting process is administration overhead costs. So these will often be allocated in a particular manner, but they do often draw attention very quickly to the warden of perhaps patterns or incorrect allocation methods. So to the extent that you don't meet an expenditure requirement for a reporting year, a party can obviously seek a grant of a certificate of exemption under Section 102 of the Mining Act. Under expenditure is not a precondition or requirement to the grant of an exemption. That was recently considered by the Supreme Court and Regis Resources and the Minister for Mines. A certificate of exemption may be granted if a holder satisfies the prescribed criteria under Section 102.2 or for any other reason under Section 102.3, for example, project-wide expenditure. A third party obviously may object and concurrently apply for forfeiture for non-compliance with expenditure requirements. So we often see these go hand in hand. If an objection is made or a forfeiture application is made, then it goes before the warden to consider and then provide a recommendation to the minister. The warden will also take into account in considering the exemption application mandatory considerations under Section 102.4. And that relates to previous exemptions granted, your historical expenditure, and what work you've done on the mining tenement. So sometimes we will often use LandTracker, for example, to track and collate that historical expenditure data, which is very useful. We are seeing arguments being run that notwithstanding a tenement holder satisfying the criteria of a prescribed ground in Section 102.2 of the Mining Act, the Minister still has a very broad discretion to refuse the exemption application. So basically, exemptions do not offer as much comfort as historically they have done, and the prescribed grounds alone may not necessarily get you there. Very briefly, I just want to touch on forfeiture applications. Many might know that a grant of an exemption will often be a complete defence to a forfeiture application for the same reporting period. The consequences of a forfeiture application are serious because a tenement obviously may be forfeited outright or a penalty imposed of up to $10,000. The issues on forfeiture applications are very wide-ranging and complex, and so will often require legal assistance to navigate those. But I think in essence, these types of proceedings are not won or lost on how you manage the proceedings as such, but how you actually paper what happens before and during the reporting year. Good evidentiary and contemporaneous paper trails make it much easier to prove expenditure and win. Thank you. And if you don't, it's really hard to win and you're taking a really big risk. So this is particularly so in forfeiture applications where the warden will actually look behind your Form 5 reports and will review the expenditure and what you've got to prove your expenditure. Less so where we see in exemptions under Section 102.2H. There's some case law to the contrary that you don't necessarily have to go behind the Form 5s, but that's also a little bit of a grey area. So some practical tips on these types of proceedings. Plan ahead. Companies should start thinking before and during the reporting year if an exemption is needed and the grounds of the exemption, and start creating that paper trail early. Don't wait to the end of the year and try. Work with your exploration team to have good contemporaneous notes. and records of exploration plans and developments. Set up a bit of a system to track and allocate expenditure across tenements or teams, and be consistent in the way you record your expenditure each year. There's no double dipping. Track your tenure or perhaps neighbouring tenure for vulnerabilities, which you can use to implement strategies to either protect or seek out new forfeiture opportunities. And regularly monitor mineral titles online and TenGraph, and equally your lawyers or your representatives should be doing the same, and at least know their way around those platforms. So that actually brings me to the end.